turn to the second case on our docket. And before we do that, I apologize for the brief delay we've had in the proceedings this morning. But we now do move on to the second case, Dodgen versus Grijalva. And I apologize if I mispronounce that. Counsel for the petitioner, please proceed.
Kansas Gooden for Petitioner Dodgen. I'd like to reserve 4 minutes for rebuttal. May it please the court. Like the last case, we are here again asking this court to treat civil plaintiffs and civil defendants equally in their discovery obligations and opportunities. Again, we believe this will foster a balanced search for truth and ensure a fair trial for both parties. Several years ago, again, this court decided Worley versus YMCA, and that court really upended the law in several areas. It changed the law with regards to referral relationships for plaintiffs' law firms. Before that, the defense was able to get discovery of that referral relationship and impeach those doctors in front of the jury. After Worley, that was not allowed. The court also found that that referral relationship was protected by attorney-client privilege. Where the court, the majority opinion in that case, it kind of went farther than it had before in the past. It basically found that that referral relationship, that telling of a client to go to a doctor, was made in furtherance of the rendition of legal services, not just for obtaining medical care. It also extended attorney-client privilege not only to the communication, it extended it to the underlying fact. So
what's your best case for the proposition that in fact that information, that exchange is for some purpose other than in anticipation of litigation? That is, it's for medical care and it isn't in fact sought for advancing some theory or making some claim?
I mean, the best case I actually think is not a case, but it's actually the text of the attorney-client privilege statute 90.502 that specifically states that it's in furtherance of rendition of legal services. Going to a doctor is not legal services, and that is just based on a plain, ordinary reading of that text. And again, extending to the underlying facts versus just a communications between attorney and a lawyer, there's a lot of case law on that. There's cases from the U.S. Supreme Court. Off the top of my head, I think the leading case is called Upjohn on that issue. So that case, Worley, really upended this for a lot of reasons. We are here today specifically, there's language in the majority opinion that we believe that should be applied evenly, or the Worley opinion needs to be overturned. Specifically, that Allstate v. Bosher does not apply to a party to a lawsuit, does not apply when it's not a party to the lawsuit. The insurance company in this case is not a party. We also believe that the attorney-client privilege, if it's privileged, that referral relationship is privileged on the plaintiff's side, it needs to be privileged on the defendant's side.
Can you imagine a circumstance, leaving aside the categorical statement that if it's privileged on one side, it must be privileged on the other? Would you concede that some consultations with a physician, say on the plaintiff's side, could be privileged? Here's a hypothetical. Let's say a question in dispute, a matter in dispute in a car accident case is the speed at which a party was traveling. And the plaintiff consulted with a physician to establish that the injuries to the victim were consistent with a speed that is a matter in dispute. Would that consultation be more privileged or privileged at all because it goes to anticipating claim or defense in the litigation?
So specifically under that hypo, that type of doctor would have to be a biomechanical expert. And so once you get into that expert realm, I don't think that would be privileged. And number one, there is a third party in that conversation. When you have a third party in the mix, that destroys the privilege, number one. And there's medical records documenting what is going on that is being disclosed, which would also destroy the privilege. So I think there's problems with the privilege of these referral relationships getting disclosed in the first instance. The communication that I think would be just a lawyer and a client having a conversation about legal strategy in the case, and it's just them, I think that's privileged. But the underlying facts of the referral relationship that flows between the law firm and that doctor, that is what's not privileged. And it's those underlying facts that Worley extended that attorney-client privilege to that has really caused havoc in this area of law. And again, Worley just really upended things in this area. And Worley has not been applied even-handedly on both sides. It's essentially been used as a sword and a shield by the plaintiffs. They will refuse to respond to discovery and provide any answers to experts. And that's the case in our record here below. But then they seek a ton of experts discovery from the other side. So the jury's only left with hearing impeachment on one side of the case. And as I stated earlier, these cases are truly battle of the expert cases. It comes down to credibility. Who does the jury believe? And if the jury is only hearing that the defense's doctors are the ones being paid and have a financial interest, that always starts the defense behind the eight ball. So I think this court has several options to really address this issue head on. In all three of these options, I think the focus is making the discovery obligations and opportunities equal, and you strive for a fair balance at trial. And I will say, none of these are perfect. There's downsides to all of them. But again, it's just striving for a fair and balanced trial. But number one is overturning Worley. And I do think this is the avenue in the case to do it. And this will allow both sides to get the information. Number two, this court could hold that the reasoning in Worley applies to all non-parties, both plaintiffs and defendants. The downside of this is in, for instance, like cases where the insurance company is the party, that impeachment evidence is going to play a huge part in that trial. And then number three is limiting bias impeachment to Rule 1.280 for everyone. And that's what the doctors argued in their amicus brief. And that they argued focused and would protect their constitutional right of privacy. Preparing for these arguments, one thing I noticed about the Bosher case, the actual expert in Bosher was a national corporation, and the constitutional right of privacy within our Constitution wasn't considered and did not apply because it was a corporation. Whereas the doctors in their amicus brief, they are natural persons, and so it would apply. And then the doctor in our case is a natural person. So I just think that's one thing that this court should kind of take into consideration that I don't know was under consideration during Bosher. Does the court have any questions?
All right. We will move to opposing counsel.
Thank you.
May it please the court. Good morning. Douglas Eaton on behalf of the respondent, Kaitlyn Grijalva. I want to start kind of at the end here. Something that Justice Muniz wrote a couple weeks ago in the DeSantis versus Thompson case. I want to point out that the petitioner here, Allstate, did not ask for reversal of Worley as a remedy in its initial brief, in Yunkin in its initial brief. The only time they asked for this is in a reply brief. This is the first time they made the argument that Worley was wrongly decided. That's too late. You can't make an argument for the first time in a reply brief because we don't have an opportunity to respond to it.
Excuse me.
Yes.
I'm going to give you more time to set things up, but I sort of see where you're going. And you've heard my questions already. And so it'd be helpful to me, at least, if you sort of followed this outline. The first question is, do we have jurisdiction? Okay. Can we answer a question at all? The second is, should we exercise this jurisdiction? The third is, with respect to what I see in the vernacular as the primary question is, do the rules of discovery, and including the procedure rules and common law rules, apply equally to all experts? And so what is the answer to that question, or how should we answer that question and why? And then second, do we answer the second question is, what are those rules? And that is determined by, do we let Worley apply to the defense side, or do we revisit Worley? And then shouldn't anything else be determined later in rulemaking in terms of what the rules should be for discovery in this area? So if you have all those, if you could follow that outline, that's sort of the order I think our questioning goes in, and I'd appreciate your thoughts on that. I think they might be helpful. And
that's similar to the outline I was going to proceed on once I addressed the quote I wanted to raise from Justice Muniz. If I just finish that, and then I'll turn right to this outline. In Thompson, he wrote that it is not our role to impose a remedy that the petitioner has not requested and that is inconsistent with the petitioner's stated goals. So again, the petitioner did not request anything with respect to Worley until the reply brief, and that's too late. So let me turn to jurisdiction. My case is a little different from the first case in that we have a jurisdictional defect in the filing of the notice of appeal here. It was filed after 30 days from the issuance of the order in this case. And the rule is very clear that you've got 30 days, and this is jurisdictional, and they didn't file it. Now, it's unusual the way the Fourth District did this. They issued the order, then they issued an opinion subsequent to it. The opinion was issued within the 30 days, and petitioner still had time within that 30 days to file the notice of appeal. They didn't do so. Now, they kind of just wave this away and say, well, they filed the opinion later, and therefore we were timely. But that's not what the rule says. The rule says the decision. The decision is the order that was issued by the Fourth DCA. This court has repeatedly made the distinction between an order and an opinion, a decision and an opinion. So from the outset.
Mr. Eaton, so I understand your argument that you've made in your brief regarding that aspect of jurisdiction. Assuming that we disagree with you, do you think that there's something about the posture of the case below or the nature of the question that doesn't give us jurisdiction under Article 5?
Yes, Your Honor. And that is that the district court did not pass on the question, which is, should Worley be extended to fit this fact pattern? It did not answer that question. And this court has repeatedly stated that, and there are numerous examples that I provided in my brief. Sagat v. State was one, which was a similar type of question. And in each of the cases that I cited, the question was, did a change in the law apply to this new factual situation? It's very similar to what the court is asking here. Did Worley, when it was written, did that change the way we should treat this type of discovery from an insurance company? And in Citizens Property versus San Perdido, in Sagat v. State, and let me get you the other cases. Speedway Super America and Mercury Motors Express versus Smith, all cases from this court. the court denied review because the district court did not pass upon the certified question. And we believe that it did not do that here, so this court does not have jurisdiction. Now, I will note that in Saugat v. State, this court did go ahead and use the rulemaking, its rulemaking power to address the issue, which this court always has the ability to do. But it did not have the ability under Section 3 to actually to address the question because the lower court did not pass on the question. Now, the standard of review, if the court does...
Mr. Eaton, if we could go back, and I appreciate you linking your argument to the language of the appropriate provision in the Constitution with respect to that issue. But back to the first issue that you raised in your brief, do you recognize that if we agreed with you on that position, it would mean that some questions could never be answered? In other words, if the lower court, the district court, had the jurisdiction to enter an order and then reserve jurisdiction to enter an opinion later, and there's no 30-day deadline on that jurisdictional deadline. So as long as they can reserve for longer than 30 days. And I think that that's the law. They still have jurisdiction to issue that opinion more than 30 days after they issued the order. Then that would put us in a posture where there are questions that are not appealable. That is sort of the end result of your legal analysis on that more basic procedural jurisdictional argument. Is that correct?
Well, again, the rules, it's a bright line rule. I don't know why the appellate court chose to do it in the fashion they did. Maybe the answer is that they shouldn't do it that way. Issue the opinion with the order. There wasn't any reason, there wasn't any rush why they had to issue an order, which I believe, by the way, had enough in it that she could have sought a conflict review from this court based on conflict.
Yeah, but we're not talking about conflict review. We're talking about our jurisdiction under the provision for a certified question.
Okay. If the appellate court issues a certified question 30 days after, then yes, under the rule, there's no exception for opinions issued later. It's a bright line rule.
The question is, do they have jurisdiction to reserve more than 30 days and then issue an opinion? Because it would be nonsensical to say, if they did have jurisdiction to do that, that the party's required to file a notice seeking our review of a certified question that hasn't been issued yet. I mean, that.
Well, look, I agree it's a very unusual situation, but I can think of circumstances at the trial level. For example, if I file an unauthorized motion for rehearing on an order that I have to appeal within 30 days, and the trial court hears it and denies my motion after 30 days, I can't then appeal that order denying my motion for rehearing. It's too late, even though the trial court kept jurisdiction and heard it. So those are circumstances exist where the rule affects what seems to be something unfair, but the rule nevertheless applies. And jurisdictional
I think the more apt
rules,
analogy there, would it be a more apt analogy to say that I filed a timely motion for rehearing, the trial judge didn't granted it or clarified more than 30 days later, and then you can't appeal the order on the motion for rehearing. As long as the trial judge had jurisdiction to rule on the motion for rehearing, wouldn't you have an opportunity to appeal from that? It wouldn't be linked to the initial order that didn't even have the analysis or ruling that you want to appeal, right?
Well, if the ruling is granted, then there is no basis to appeal because you're still in court. So I'm not sure that's necessarily the same thing here. I don't want to get too bogged down on that. I'd like to get into the rest of the court's questions. It's a technical issue. I think it's one that the court can dismiss this petition on solely. But if the court wants to hear it, let's address the merits. So the question of what standard this court needs to apply to this, I want to go back and address that because Ms. Gooden was arguing that the court decision is de novo and it's not approaching it from a certiorari standard. That's simply incorrect. She actually cited to Lefebvre v. State, in which Justice Kennedy dissented Justice Polson concurred, joined in that dissent, where the majority wrote that the district court decision is reviewed de novo, but Justice Kennedy wrote the question should be answered in the affirmative. The results reached by the second district should be approved. Failing to uphold the second district's correction of the trial court's error in this case works a miscarriage of justice. That is the certiorari standard. So that's the standard this court needs to apply to this question. Was there a deviation from the law? And the answer is no. The court did exactly what it was supposed to do. The trial court did, and the district court did. So I do not think the court should exercise jurisdiction. I do think it should find that there was no miscarriage of justice. There was no the law was applied properly. Now, let me move on to the broader question here, the issue of fairness. I think where there is some confusion here is the fact that we're dealing with a very unique set of experts. We have the law of Bocher is being applied equally. It's being applied equally to both sides, and that's under the Morgan Collin case, which says that you can come to a plaintiff's law firm and you can get evidence of the financial relationship between it and its retained experts for trial. And that is the law of Bocher, and it is applied equally to both sides. If I retain an expert for trial in a medical malpractice case, if I've retained him 100 times, you can get that information from my law firm and use that to impeach him about our financial relationship, just as the same way that we can do that for Allstate and its retained CME experts. So the law is being applied equally. We have a unique set of experts called hybrid experts, which were first discussed back in 2009, long after the jurisprudence.
Okay, let me give you an opportunity to address this. So we agree that what's discoverable is related to what's admissible, and what's admissible is determined by the Florida Evidence Code and the Rules of Evidence. And the Rules of Evidence 90.702 is talking about testimony of experts, and it doesn't differentiate between. It doesn't make the differentiation that you're making. So why should we, by case, decide that some experts are different than other experts when it comes to something as basic as financial bias discovery, so that one expert is what the party can't find out with one expert in the courtroom testifying as to the exact same issues, whatever those issues are. Your expert, however he got there, retained or treating, is testifying to the exact same issues, but the other party can't get that expert's financial bias information in order to impeach and let the jury know about credibility issues. On the other, so where are you getting this distinction from, and why does it make sense?
Well, I'm getting this distinction from this court's opinion in Gutierrez v. Vargas. This was 2018, 239 Southern 3rd, 615. This court made a distinction between treating physicians and experts. And what this court said is a treating physician is a fact witness and testifies to past facts based on personal knowledge. The treating physician's perception of the plaintiff's symptoms, their diagnostic opinion, and their recommendation of a particular treatment are all facts and issue. An expert witness testifies with the benefit of hindsight, whereas a treating physician does not. This court has made the distinction between treating physicians and retained experts. So that is the basis for that distinction. And that is in fact
why is that a
Worley.
relevant distinction when it comes to whether that expert is biased based on a financial incentive to testify in favor of one party or another?
Well, you're asking whether the issue of bias is relevant, and the answer is it is. Worley never held that it was not relevant. Worley said you can't get it because of attorney-client privilege. That's it. That's the distinction. It never said it was not relevant. And in fact, it did say, in fact, that the existence of letters of protection was brought out in Worley, and that goes to show financial bias as well. It shows that the physician has an interest, a financial interest in winning this case because that's the only way they get paid, under a letter of protection. So that is one way that you can show financial bias of a treating physician. But they simply held that the fact that I referred a patient to a doctor is an attorney-client communication. And that's the entire holding of Worley. It was not based on the fact that it was a non-party. They did distinguish it, but that wasn't the holding. The holding was the attorney-client privilege protects this information. And so if the court is interested in addressing that unique situation,
Wait, so let me just
because
back
again,
up.
the law,
You would agree that the impeachment evidence is equally, it would be admissible against the
Yes.
expert. Okay. And so fairness would dictate that it should be discoverable unless there's a reason not to discover it.
yes. I mean,
Okay.
that's
your
anything
only
under
reason,
Rule 1.280. Remember,
So if you agree with the general principle that the discovery rule should apply evenly to all parties, then the only reason we would ever say it's not discoverable is if we're right that it's privileged.
that's correct. Rule 1.280 has two prerequisites. Is it relevant, and is it privileged?
So
That's
if
it.
it's
That's
if
the
it's
analysis.
if it's really not privileged and we made an error, doesn't basic
discoverable.
fairness mean that we correct that error so that the law and the rules can apply evenly to all parties and when it comes to impeachment evidence that's introduced at trial?
Well, this issue of fairness, to me, that's not a textual-based argument. It's not. There's no legal argument for that. That's kind of what Justice Scalia, when he talks about judges making decisions based on what's.
Isn't the textual-based argument that Section 90.702 Florida statutes and Rule 90.702 of the Rules of Evidence treats all experts the same? I mean, that's the textual.
But this court doesn't treat all experts the same. I mean, you'd have to go back to Gutierrez v. Vargas and say that they're the same, because they're not. Treating physicians are not retained experts. That distinction has been made very clear by this court. So you have to treat those separately, and if you want to craft a rule specific to them, then that's fine. But right now the law does treat retained experts equally. So we have retained experts on both sides are equal, and then you've got this subset that does not exist on the defense side. It only exists on the plaintiff side. So it's not an equal protection issue because they're not similarly situated. And that argument wasn't even frankly made. So if you want to carve out and create a rule with respect to these specific experts that have only been designated as such since 2009 and weren't even taken into account in Bocher and Springer and its progeny, then the court should do that. But it should do that in a manner that takes in evidence, because there's not going to be a one-size-fits-all rule here. As Mr. Nation noted, there are circumstances where the referral is part and parcel of mitigating damages in the case. And there may be situations where a secretary says, here's a list of doctors, go to one of these. And maybe that's not protected. But if I have a conversation with my client and say, you should go to this doctor because he's a very good doctor and he's going to help treat you, then that is protected communication. So that's why I think if you're going to go down this road.
What part of that communication was in anticipation of litigation? You should go see this doctor. He's good. You should see him. What part of that is in anticipation?
It only arises out of my relationship as me as his attorney. That conversation wouldn't happen otherwise. I represent him. I'm saying you have a duty to mitigate your damages.
That rule, we can agree, proves too much, right? If we cast the blanket of privilege over everything that would not happen but for your existence as counsel, then things like your invoices would be privileged, or how much your hourly rate is would be privileged, or all sorts of things that aren't privileged. I guess what I'm trying to, if we agree that the communication that you're seeking to defend or protect under the shield of privilege is diagnostic in nature, related to medical treatment, help me understand how that's in anticipation of litigation.
Well, let me just address one thing, Your Honor. I'm not asking to protect anything like that. I'm here on behalf of my client, and I'm saying this court should answer the question in the negative and deny this petition. Okay, you're asking me to essentially issue an advisory on something that I'm not involved in, and there's no record in this case about. That's why I'm saying this case is not the mechanism to decide this issue. I think that if you're interested in dealing with this issue in Worley, then the way to do it is through a rulemaking process in which evidence of how this occurs is done so that you, Your Honor, can make a determination as to where to draw that line. Because this is not the case to do that. You can't draw it based on no record, no evidence, on a case or controversy that has nothing to do with a relationship between a law firm and a treating physician. This case is about an insurance company has to give us how much money they pay their retained experts. That's it. That's what this case is about. That's what Grijalva is about. And so this is not the appropriate case to answer the question of how to solve the Worley problem. That's our position.
Okay,
And I can see I've gone over my time. I'm happy to answer any further questions, but.
All right, we thank you, counsel, now for rebuttal.
Thank you.
Opposing counsel has relied on Gutierrez versus Vargas for the distinction of treating physicians versus experts, but he actually ignores the wording of that opinion, because this court's opinion actually says that the treating physicians can become experts once they start giving expert opinions. And so just because you're a treating expert, you're not automatically protected forever. And that's exactly what's going on in this case. The treating physicians in this case were disclosed as expert witnesses, and that's found on page 89 through 91 of the record. And all of the treating physicians were disclosed. And so all of these physicians are giving causation, permanency, future medical care, and expert opinions. And so this goes to the fundamental fairness of the case. We have to look to first principles. Is this fair? And it is not. And no matter how much legal gymnastics they try to make this between a treating physician versus a retained expert, it is still an expert who is testifying in front of the jury and giving expert opinions. And that jury is judging the credibility of these doctors, and only hearing one side's impeachment bias, it really does a disservice and denies the defendants a fair trial. It makes everything lopsided. The standard of review was raised. When you're dealing with certified questions of great importance on legal questions, the standard review is de novo. So regardless of how the underlying vehicle was created, whether it was a writ of cert, once you have that certified question on a legal issue, this court reviews that de novo. And that's how we're here.
Counsel, could we hear your best response to opposing counsel's argument that this isn't the right place to make the merits adjustments that you're suggesting to the rule, but that instead, with the benefit of comment and the rulemaking process, that is?
Well, again, so I think his argument's kind of twofold. Number one, going through the process, this case law did not develop because of the rule. Bosher specifically said else and Rule 1.280 did not apply. And so this entire line of cases, beginning with Bosher, Springer, all of that, it developed outside of the rule and through the common law of the state. And so I believe that this is the appropriate vehicle because of that. And this court can correct the common law of this state. And number two, it seems like they're making the argument that it's not the appropriate vehicle because the underlying case was on a writ of cert. And it's not necessarily like the plaintiff bringing it, but if we wait to that case, it will never be brought because the plaintiff is not going to be filing an appeal on Worley. This is the case to address Worley. This is the case to address the fairness of the parties. This is the case to address how Worley has created this uneven treatment between everybody. And we did address it in our initial brief. In the opening intro, it states the jury needs to hear the information from both sides or from neither side. So this is the case. And so we are asking this court to address this issue head on. The parties have to be treated equally under the eyes of the law. And for that reason, we are asking for this court to basically fix the issue and to do that and strive for that balance, truth-seeking function that Elkin strived so hard to achieve. Thank you.
Thank you, counsel. We thank both of you for your arguments. The court will now stand in recess for about 10 minutes before we proceed to the last case on today's docket.